SJC-12479, Commonwealth v. Jose A. Martinez, and SJC-12480, Commonwealth v. Stephanie Green.
Thank you.
Mr. Keene, good morning.
Good morning. May it please the court. Benjamin Keene on behalf of Jose Martinez and Stephanie Green. I'm joined by attorney Nancy Kaplan. These two cases are before the court on reported questions from two district court judges on separate cases raising related questions pertaining to whether and if so how a defendant whose conviction has been invalidated, where there is no further prospect of prosecution, may be refunded conviction-dependent monetary exactions. I want to touch on four issues that are raised by these two cases. First, as these cases have been briefed, particularly by the AGO in the Martinez case, there is no dispute as to what the governing law is here. It is Nelson versus Colorado, the Supreme Court decision from 2017, which holds that any money exacted from a defendant upon and as a consequence of, I'm putting those in quotes, of a defendant's subsequently invalidated conviction must be returned as a matter of due process of law. And the reason for this is because the defendant whose conviction has been invalidated is entitled to the presumption of innocence. There's also no dispute, just to clear the landscape, that this court's decision about 4 months before Nelson came down in the Martin case is no longer good law. So,
Well, it's good law as to what the statute says, but the defendant in that case did not make any claim under due process. So I recall specifically there was no due process argument made and therefore not reached. But in any event, I think we take your point. Nelson versus Colorado is the governing law.
So there's also really no dispute as to what Nelson requires as a matter of what process is due. And this is at the very end of the Nelson opinion, where they say that to comport with due process, a state may not impose anything more than minimal procedures on the refund of exactions dependent upon a conviction subsequently invalidated. So that's really what Nelson is attempting to achieve is a simple, cheap, and efficient way of defendants who are presumptively innocent to get their money back. It's really about an access of justice question. And
how do you square that requirement with what would happen if you had to decide whether a victim witness fee is going to apply to a misdemeanor or maybe even another felony? That doesn't seem like a minimal procedural issue. That seems to me to be really complicated case flow management and raise all sorts of other nightmare issues.
I totally agree, and which is why I think that this court ought not to adopt the suggestion of, I believe it's the Attorney General's office in Martinez, that as a matter of course, as I read the brief, judges should be scouring to see whether some conviction-dependent monies could be redistributed to surviving convictions. The only law that's cited in support of that is an appeals court decision called Zawadzki, which does say that a judge has discretion to redistribute fees or costs to a surviving conviction, but also goes on to suggest that if the defendant has already paid the price, or if there are other equitable reasons not to redistribute, the judge should let the case lie, I believe is the language. And it seems to me that as to this category of cases, Dukin defendants who have been waiting for years to get their convictions vacated and who have been burdened for years with all of the collateral consequences of these invalid convictions, they cannot really be made whole in a global sense, they're never going to get their liberty
So if a
back. They're never,
So if a Dukin defendant has a drug distribution charge and 7 firearm offenses and assault and battery by dangerous weapon, and they were on probation for 3 years, they paid all the fees and fines, they have a Dukin acquittal, right? It's been vacated. Your position is it doesn't matter whether or not they have the firearm offenses in the ABDW, they're entitled to all the money back that they paid while they're on probation.
I guess I wouldn't say it doesn't matter. I would say that in order to achieve the minimal process that Nelson requires, it would be contrary to that principle if judges were required to scour the docket sheets to see whether it would be possible to shift some of the costs around. There may be cases, not before the court here today, in which the Zawadzki discretion should not be completely thrown out the window. But as a matter of course, I would say no. And that's really where I take issue with both the suggestion in the AG's brief and also the green brief from the probation department, which is suggesting that as I read it, as a matter of course, judges should look at these motions and see if there's concurrent probation on surviving convictions.
But did Nelson have any of these complexities? I mean,
Not that I
when they-
know.
So-
It's not presented that way.
So, I mean, when they talk about minimal process, it may be because they had simpler cases.
I think the minimal, I wouldn't agree with that. I think that the minimal process is pertaining to the overarching concerns of the case, which are presented in the vast majority of cases that we're going to be talking about, where the goal is to return the defendant to the status quo insofar as possible. And as to most of these cases, it's the Dukin cases that have driven the case.
This really goes to how far you're asking us to reach, because as I read the amicus briefs, it says, butt out, just decide the cases in front of you, don't mess up our federal case.
Absolutely.
And you're not asking for a global.
No, we are not. There is a pending class action, which we.
So if we decide the cases in front of us, we don't have these complexities about mixed convictions.
There's one reported question that addresses this redistribution issue. That's from Judge Abaney in the Martinez case, whether $50 of the $90 victim witness assessment should be redistributed to the surviving misdemeanor conviction for operating operating without a license. And I think the answer should be no, for the reasons that I said, that it would not be a sound exercise of discretion to accept the Commonwealth's invitation for judges to start nickel and diming Dukin defendants.
Because it doesn't rise to the level of my hypothetical of the 7 firearm cases. It's not intertwined like the hypothetical I gave you, where
It's the other end
It's the other end,
of
yeah.
that scenario, I would say.
But going back to Justice Gaziano's hypothetical, if you have individual who is on probation for a drug conviction and concurrent probation for 3 firearms cases, are you saying that vacating the narcotics conviction means that he gets the money back for the probation fees, even though he was on probation also for the firearms?
Maybe, depending on, and this is why this hypothetical does not accord with the simple process that we hope will apply. But it may well be that would be an unfair way of handling a concurrent probation in any particular case, notwithstanding what the charges look like. If everybody knew that the most serious case and what the defendant was really on probation for was a drug case.
In terms of your so-called minimal process, which I
Right.
think must be viewed in view of the fact that the Colorado process required a determination of innocence, which clearly is no longer required. But You want us to look back to the sentencing done in 2008 and decide whether the probation was really, the gist of it was the narcotics case as opposed to the firearms case, and that's going to be in accord with minimal process?
No, I'm saying the opposite, that the presumption ought to be that, that there is no redistribution and that the,
How do we know that the probation fee was paid for the narcotics probation as opposed to the firearms probation? He's on probation for all sorts of things.
well, you, if someone is on concurrent, first of all, let me just say, this is not a reported question. So one answer is, don't answer a question that hasn't been asked. Also related, for all I am led to believe, these scenarios are being negotiated in the Foster class action. But if you just look at the facts of the Judge Abani's case, I think you can answer that by saying it would not be an abuse of discretion to let this case rest and not shift $50 onto the surviving misdemeanor. Let me just go back to what I think the...
Before you get there, assuming we, as Justice Gaziano so eloquently put it, bud out, if somebody else comes forward, as they're entitled to, are you saying that the class action is going to bar other defendants from coming forward to courts to say, give me my money back because they're a member of the class?
No, absolutely not. And I believe the AG says as much in their brief that these are individual motions which should be...
So assuming you prevail and your client gets back the whatever cents of money, why would we not be getting hundreds, perhaps thousands of Dukin and Farrak defendants now coming forward to say, give me my money?
I think there will likely be an uptick in motions for return of these funds if this court answers the questions in the manner that we have said. I think there will also be even renewed vigor in settling the global picture in the class action, but there will be some unknown number of individual cases, in addition to the two before you, where, for whatever reason, the defendants opt out of the class action, or it doesn't fall within the scope of it, or for whatever reason. And what that number is unknown, but it also needs to apply, these are not just Dukin defendants. This issue applies to anyone whose conviction has been invalidated.
Right, I understand that, but we happen to have thousands of Dukin and Farrak defendants, which is...
Right, that creates
So if these, let's assume it's only 1,000 of the multi-thousand individuals, does CPCS believe they have a right to counsel with regard to the adjudication of that motion?
I think the short answer is yes. I think that if push came to shove, we would be confident in saying that there is a right to counsel that flows from the Bridgman II remedy for any defendant who is unable to navigate the system by him or herself to get the relief that this court plainly contemplated. Which is why Mr. Martinez is no longer pro se. At the same time...
But in Bridgman II, CPCS said, we need a global remedy because we can't possibly represent the thousands of Farrak defendants who are going to come forward. It's going to swallow us up. It's totally untenable.
I understand
and now
the
we've
tension.
got Dukin defendants and Farrak defendants,
Right.
and CPCS is saying, butt out, no global remedy, we'll handle it.
There's a distinction here, and I think we're saying butt out of, if I may use that term.
You're not putting it that way, we know that.
I apologize for that.
of questions that are not, have not been reported to you.
Refrain from.
And answer the questions that have been reported in a manner that will permit the vast majority of Dukin defendants, or other defendants for that matter, to go into court and fill out perhaps a form motion saying, and this is how the process we believe ought to work, that alleges, I had to pay money as a result of my conviction. I paid the money. My conviction has been thrown out, and there's not going to be any further prosecution. If that facially adequate motion has been filed, hopefully without the assistance of counsel, but if it's complicated, then we'll do what we have to do.
Well, to reconcile this point about counsel, though, so if the relief is so complicated that it requires counsel, then how does the nature of the relief have the minimum procedures required by Nelson?
So let's assume a pro se defendant fills out the motion I'm contemplating, the form motion that the district court has produced as a result of this decision in this case. The district attorney's office had secured the conviction, will get the motion, will review the file and any records that it may have, and either agree to it or dispute it, which didn't happen in the Green case. But that's what ought to happen, at which point the judge will sign off, hopefully, on an undisputed amount, and it, in theory, can be relatively cheap, easy, and efficient. What the Commonwealth has recommended, and I see I'm over time, but if I just may respond to this, in the Green case, there's a $5,000 fine. And the Commonwealth did not dispute that she was entitled to have the fine returned, but they did say, we don't think that the record makes clear whether she paid it all. Now, they have since told me, as of yesterday, that they're prepared to withdraw that request for an evidentiary hearing on this point, but which we are grateful for. But honestly, they should have agreed to it a year ago when we were in front of Judge.
But they may have agreed to it in that case, but I take it that issue, they're not backing away from the issue itself about whether someone actually paid the fees, right?
Right, but what they have not acknowledged is that if...
Which we have to address.
And the way we should say it should be addressed is that if there's a facially adequate motion, if there's nothing in the record that indicates that the fines or that the money was not paid or was remitted, then and the Commonwealth comes forth with nothing to rebut that record, then if there's any doubt, the defendant needs to get the benefit of it. That's how that should operate. And the Commonwealth does not accede to that protocol, which I think is important if this is going to be functional.
Is that issue?
I just wanted to ask one question before.
I think Mr. King will be here for a while.
Okay,
So,
all right. I just want to ask, I want to ask you a question about forfeited funds. Doesn't it matter how the funds or the property was forfeited as to whether or not the defendant who has their conviction vacated gets it back? Whether it's a solely, separate civil forfeiture or if it
Right.
is combined with the
Right.
criminal?
So yes, we say that in the Green case, there was a forfeiture that is tied to the conviction. It was a common type of forfeiture that happens under 47B of the forfeiture statute, which gives final jurisdiction to any court that has jurisdiction over the related criminal case, and pursuant to which it is very common at the end of a guilty plea for the Commonwealth to get up and say, and Judge, we'd also move for this money that was taken at the time of arrest to be forfeited. Motion allowed. We say that that is conviction dependent under Nelson, both because the legal basis for the forfeiture is the guilty plea, and because as a practical matter, and the affidavit submitted by the chief of the forfeiture division of the Middlesex DA's office confirms this, they don't bother filing a separate civil action in Superior Court under 47D of the forfeiture statute unless they're talking about a lot of money, over $2,500. So in short, in this 47B context, the Commonwealth hitches its forfeiture wagon to the conviction, as it were, which is legal, It's quick and dirty, but the consequence of that is if the conviction gets invalidated, that is for all intents and purposes no different than a fine or a cost.
Okay,
And
So
but
you-
Commonwealth versus Brown, I'm sorry,
No, go ahead.
Commonwealth versus Brown says that even a 47B proceeding is a civil in rem proceeding, albeit a foreshortened one.
it is, that's what the law says, but the factual basis for that civil forfeiture under 47B is what the defendant just said he or she was guilty of. And with the with the conviction invalidated, the legal basis for the forfeiture is, in the words of Nelson, we would say, has been similarly erased. And so there is no valid basis for what happened. And it's stipulated in this case, and this is the common practice, it happens, immediately upon the acceptance of the guilty plea. This is a tack-on kind of forfeiture.
And if what is forfeited is not only money, but I believe a car can be forfeited under 47B, correct?
Yes, anything, yes, and as a practical,
Defendant get back the car?
or its fair market value, I would say, yes. If it's a conviction-dependent 47B forfeiture of property, I think the defendant's entitled to it either being returned or compensated for that.
So we'd have to
That
ask-
doesn't happen often.
We'd have to ascertain the fair market value at the time of the 47B hearing.
Presumably, I haven't thought through that. But the vast majority of these district court 47B forfeitures do not involve more than $2,500 of cash or any other substantial property. We're talking about almost as an afterthought, the prosecutor says, there was some money that was found in the defendant's pocket after he was arrested, $114. We'd like to forfeit that. That'll be allowed, and it's split between the DA's office and the police department. That money, under the principles of Nelson, should go back to the defendant whose conviction has been invalidated. If I just have one
Yeah, if I
quick
can
moment.
save that point, I want to go back to the
All right.
practicality of our superintendent's authority. Let's assume that we decide only the case before us and defer putting together a global resolution. How long do we wait for the class action to be resolved in federal court? Do we wait 3 months, 6 months, or do we say, this may take 2 or 3 years, you may try the case? How long do we wait?
I think events will dictate the answer to that question. It appears to me, and I don't want to speak on behalf of the AG's office, which is here today, I believe, but every impression I get is that they are motivated to not burden this court with yet another administrative nightmare for how to provide a full and adequate remedy to the victims of these drug lab scandals. I think my takeaway is that we have learned something from all of what we've gone through, and they are attempting to not bring that case to you.
Okay, with all due
How long we have to wait?
With all due respect, the burden is not on we seven. We can write a decision and we can furnish a global remedy. The burden is going to be on the trial courts and the probation office and on the judiciaries and the staff of the trial court, which is going to have to administer all these matters and figure out how much was due in thousands of cases and then give notice to the individuals. I mean, it's not really about us. It's about the trial court and probation burden.
Right. And that's why I do think it's reasonable to expect that there will be individual motions for return of property that will be presented in the interim, whatever that is and whatever the number is. But I don't think, I can't stand here and tell you when we're going to file a 211-3. Believe me, there's no contemplation for that if we can avoid it.
But what do we do if we get hundreds or thousands of cases in the interim that are, and then inundated not only our trial courts and the probation service, but also burdening CPCS, who has to assign counsel for each of those cases? Do we wait and say, we'll let you folks sort it out in federal court? Or at some point, do we say we have obligations under our superintendent's authority to protect the trial court and the court system?
Well, I think at some point, if things actually fell apart, as you know, in a worst-case scenario, yes, you'd have to do something. But honestly, I think those questions are better addressed to the assistant AG who's in that case. And you know, the Commonwealth does not. The AG's office doesn't have any interest either in burdening the trial courts with thousands of these motions. So I don't think we're talking about many thousands, but I don't know. You know, there is an unknown factor here. I grant you that.
I mean, there's got to be many thousands, right? I mean, if you just add the Farrakhan and the Dukem one. Case.
Right. What I was referring to, how many will be captured by a successful class action versus how many will be litigated individually. I have no way of predicting that.
I mean, even if you, well, I'm not sure how you're going to resolve it. Is the trial court, by the way, has the trial court intervened, or is it a party in that federal case? Or is the probation commissioner?
We are not a party, and I do not know the answer to that question.
Perhaps the AG could inform us whether the trial court or the probation commissioner has intervened, because unless you're basically going to administer it yourself, it's going to be the trial court and the probation office which is going to be involved in administering it.
It is complicated, which is why restraint and forbearance is all the wiser at this juncture. It may unfortunately be necessary for the court's involvement at a future point.
But can I ask about the payment vehicle because you're asking each court to basically pay these out of ongoing fees. I'm just not sure how that, I mean, I take it this global settlement is looking for a legislative act to be passed to pay for.
Right.
Because we're talking about probably tens of millions of dollars,
Right.
Is that correct?
That's my understanding. Again, I'm not a party to it,
But you don't want to do that. You want sort of ongoing fees to be used to pay the individuals.
Right. So yes, our position in the brief was that the trial court should pay. They're the ones who took the money. They're the ones who should pay it. The probation department says in their green brief that that's not how it works. There's a daily sweep, actually, of monies collected by the trial court, and so that money is actually not in the custody of the trial court's line item or wherever it is. It goes to the treasurer of the Commonwealth, so the treasurer of the Commonwealth should be the one who cuts the check. And to do that, there has to be a chit of some sort from a judge to the treasurer. That's fine by us.
You're comfortable, so you're backing off of your request that the court.
Yes, that request is the only statute that we could find that contemplates a refund process of any sort is the victim witness assessment statute. There is a gap in the statutory landscape as to how this should happen and at all. And that statute says that the money should be returned by the trial court, and then that amount withheld from future assessments that the trial court is required to forward to the treasurer or to the Commonwealth. Apparently, that's not the way it actually works.
But you understand that since, I think, 2009, blissfully, the trial court does not keep any of these fees, or they go to the general fund.
I have learned that in the course of this.
So it's not the trial court's money, it's the trial court collecting it,
Right.
and then it goes immediately to the general fund.
So by that logic, it makes sense that the check should be issued from the treasurer, not the trial court. And as long as that can happen with dispatch, I don't think the defendants have any.
And again, I may be misinformed on this, but doesn't that often require an appropriation from the legislature? Or isn't there going to need to be a statutory authorization for that type of payment? I mean,
I cannot see how, well, if the Commonwealth doesn't have the money, that's a problem.
well, it's not that the Commonwealth doesn't have the money. The Commonwealth has to have money appropriated for particular purposes.
Right.
Okay, I
Well,
just don't,
here
we
we
can
have-
ask the AG that, but
Yeah, but here, just as the background of the answer, whatever the answer is, here, there's a constitutional requirement to repay money that Nelson says is the defendant's money. So whatever logistical problems, aside from bankruptcy, which is a problem for everybody, but if the Commonwealth cannot say, in my view, it would not comply with due process to say, get in line.
Commonwealth can't go bankrupt, so that's not quite how it works. But
Okay, that's good to know, I feel. But I would say it would be contrary to Nelson for,
know how they did it in Nelson? Do you know how it was done in there?
no, if you look carefully at Nelson, the law that was actually at issue was changed radically during the pendency of the Supreme Court, and I do not know, and nor have I found any out-of-state law that deals with the sort of application of Nelson. Neither is there a jurisdiction, as far as I'm aware, where we have potentially 30,000 claimants whose convictions have been relatively recently invalidated. So I acknowledge that there's a looming problem, but with all respect, it's not before you today.
Could you tell us if you have anything important to say about any of the other reported questions? Have you gotten to all of them?
Thank you.
Thank you, Judge Link.
The only thing I didn't touch on is, it's not a reported question, but it has,
Going to exercise restraint either, huh?
sorry.
I said you're not going to exercise restraint either.
I would just reiterate the butt-out ethos as applied to the probation department's suggested protocol. There is nobody before the court today who would be affected by what they are suggesting of redistributing money to concurrent probations. And so there's no record for it. The record in that kind of issue will matter, so I would ask the court not to go there. And I thank you for your...
And I assume you're not asking us to address the thorny issue of restitution as to how we get it back from private parties.
It does not need to be addressed in this case, for sure. I think if push came to shove, our position would be following Nelson, which doesn't actually explain it in detail, but it does make quite clear that restitution is returnable, must be returned, and the logic of the case is it's that the Commonwealth has to return that money if they want to go after, I don't urge this, but the restitution is returnable, the Commonwealth is on the hook for it, and if they want to figure out how to deal with a third party, so be it. But
But Nelson doesn't say that.
no, it doesn't say anything.
It just says restitution is among the exactments to be returned. It doesn't, even though Justice Alito in the concurrence says this is pretty complicated and harder than it looks, it's not at all addressed by the opinion.
I acknowledge that. I acknowledge that, and it is no longer an issue here, or actually never was, because the restitution that was ordered in this case was bizarre. It was not actually restitution from a victim who was entitled to it. It was whatever it was, but it's been taken care of from the defendant's perspective, and so that aspect of the report is moot.
Okay, thank you.
Thank you.
Ms. Langston?
Good morning, Mr. Chief Justice, and may it please the Court. Jessica Langston, Assistant District Attorney for Middlesex, appearing on behalf of the Commonwealth. And the Commonwealth agrees with my brother's description of the issue before this Court. That is, that Nelson requires the return of conviction-dependent exactions, including those certain of those at issue here, namely the fines and surfines, the probation supervision fees, and the victim witness fees, but it does not require the return of forfeited money. And Nelson is very clear and explains that when a criminal conviction is invalidated by a reviewing court and no retrial will occur, as in the case here, the state is obliged to refund fees, court costs, and restitution exacted from the defendant upon, as a quote, upon and as a consequence of the conviction. It's not tied to the conviction, as my brother suggests. And the forfeiture here was not a consequence of the conviction. The forfeiture was entered at the time of the guilty plea pursuant to Section 47B because the Commonwealth is being fair in waiting until the disposition of the criminal case. So waiting until here the defendant pleaded guilty. It could have been after a jury verdict or a judge verdict of guilty. And according to the affidavits submitted below before Justice Kunis, the affidavits of Attorney Hughes and ADA Daskalakis, that's the practice in the district court. And that the practice is also that forfeiture would not occur if there was a nolle pros, if the case was dismissed, or certainly if there was a not guilty. But that's the practice out of fairness to the defendant. Under 47B or D, the Commonwealth could have sought forfeiture or could have proceeded on the forfeiture prior to.
But if the Commonwealth waits, how do we know that there was enough evidence for the forfeiture except for the conviction?
Well, yes, Your Honor, because the evidence, simply because the conviction is vacated, where the forfeiture is a civil proceeding that proceeds parallel with but separate from the criminal case. Simply because the criminal conviction is vacated doesn't mean that the facts supporting probable cause to show a nexus between the money and the drugs goes away. And in fact, in this case, there were additional crimes that the defendant could have been charged with but wasn't, namely distribution of controlled substances for the two.
Is that part of the civil case?
I beg your pardon, Your Honor?
Allegations part of the civil case?
Well, Judge...
So if they're not, then what difference does it make?
Well, Your Honor, we don't know because we don't have a transcript of what was read into the record at the time. It certainly would be where this was, and again, I would dispute my brother's characterization of a 47B process in the district court where district court judges hear these all the time, simply because for efficiency they take place in conjunction with the plea when the facts are read. There's nothing quick or dirty about them.
So the judge is the one who takes care of it, the same judge?
Yes, Your Honor.
Okay.
So the case goes forward, the Commonwealth would have filed a motion, and the judge, as Justice Greco did in this case, makes a ruling with respect to whether or not the Commonwealth has met its burden with respect to the forfeiture. Defendant Stephanie Green here, who was represented by experienced counsel, Mr. Shields, had an opportunity to object to that and did not.
There'd be no forfeiture without the criminal case, though, right?
I beg your pardon, Your Honor?
There'd be no forfeiture without the criminal case?
No, Your Honor. There could be
Forfeiture would go forward even though there was no criminal case?
The forfeiture could absolutely go forward even though there's no criminal case, simply because, and nothing in B or D precludes that, 47B or D. The forfeiture can go forward even if there's no criminal case, even if the Commonwealth can't meet its burden to prove beyond a reasonable doubt, because all the Commonwealth has to show in going forward on the forfeiture is that there's sufficient evidence of probable cause of that drug money nexus. And given the facts at issue in this case, where, as the court is familiar with the record, there were 2 controlled buys of crack and powder cocaine. The defendant sold both of these. The defendant had conversations with this undercover trooper, who was the one who was doing the buys, talking about cooking the powder cocaine into crack and how that occurs. The defendant told him you had to quote unquote shock the cocaine. And the defendant accepted $100 in exchange for 2 bags of what appeared to be powder and crack cocaine. Those substances field tested positive. Later on the evening of the second buy is when the search warrant was executed at the defendant's residence. And in response to the knock and announce, officers heard running. There was no response, so they used a battering ram to enter the apartment. The defendant was stopped in the living room on her way to the bathroom, possibly in an effort to dispose of drugs. She told the officer that she had cocaine in her pocket, and in one pocket was a clear plastic bag with 8 smaller bags of crack. In another pocket was $431. $100 of this was the buy money from that buy earlier that day. It was in execution of this warrant that the officer seized the $1,411.63 that was forfeited. There were also a number of cell phones, a digital scale, materials used for packaging.
Does
So,
the could go forward or would go forward matter? Because you might have a district court case, and I don't know where the line is, but it's $150. You're not going to have a separate in rem proceeding on that $150. The Commonwealth just isn't going to, probably for darn good reason, bother. So does could go forward or would go forward? Does that matter in the analysis?
I don't think it matters, Your Honor. I think really what's dispositive here is that regardless of the amount of money, a forfeiture, even if it takes place in conjunction with a criminal proceeding in district court, always retains its civil nature. And the case law is clear about that, and my brother acknowledges that.
But the conviction is not sufficient by itself to justify a forfeiture. There has to be demonstration that this is the proceeds or the instrumentality of the crime. Is there any proffer made by the prosecutor, as there is with regard to the plea, to indicate that, in this case, the $8,000, the 3 cell phones, and the laptop were instrumentalities or proceeds of the drug dealing?
Well, Your Honor, the $8,000, that was in conjunction with docket number 3236.
Right, the hotel room.
Yes, so here, the forfeiture that with respect to the case here that's at issue before this court today is the forfeiture in 2845.
So we're dealing only with one forfeiture, not the other forfeiture?
Yes, Your Honor. My brother is not challenging the forfeiture.
So it's just the forfeiture of the cash?
Of the $1,411.60.
Okay, and is there any proffer as to whether or not that cash was the proceeds of drug dealing, or is that just, are your arguments essentially implicit from the conviction?
Well, it was, I would suggest to the court that the probable cause of that drug money nexus is shown in the facts that I've just read to the court, which were the facts taken from the police report in support of that application for the complaint, where, again, even though the defendant had sold drugs on 2 occasions, she was never charged with distribution, and where I believe she avers in her affidavit, which was filed below, that the money was in her coat pocket. She also told the officer that after the officer found these things and executing the warrant, after she received the Miranda warnings, she said she had been selling cocaine for about 1 month, that she purchased it in Boston. I believe she said she went there about once a week, and then she sold it in Framingham. So that information taken together, I would suggest, would be sufficient, because we don't have a transcript of the proceedings below. We don't know what was read at the time, but surely on the papers that would have been, that were in the district court file, that would be sufficient.
Seems like the second category that you object to is even more complicated, which is whether the money is actually paid or not. I mean, the forfeiture, it seems like it's capable of some kind of coherent legal analysis. The whether it was paid is going to be based on all kinds of variables and record keeping and tracking. How's that going to work in the real world?
It's a very complicated process. As the court's aware, under 47D in the paragraphs that follow the initial paragraph, money, well, I beg your pardon, Your Honor, you mean with respect to?
Well, I mean, the U.S. Supreme Court talks about a minimal process, but that's really about innocence. I'm not sure they're talking about whether you've been paid or whether it was actually paid or not. If the Commonwealth is going to turn each one of these into a record-keeping exercise, which may be necessary, I'm just saying that sounds like an enormous undertaking for the court system and everybody, and probation and everybody else.
Well, and I think Your Honor is correct. It would be. Here, the Commonwealth's position is that obviously the district court is in the best position to understand their own files and their own records, and that's why, as my brother represented to the court, it only came to my attention, unfortunately at the late hour of yesterday, that in looking through records, there was one additional document that was found by probation, and then that document showed that the defendant had indeed paid the $5,000. So
that case is easy, but going forward, you're recommending basically an individualized review of whether all the fees are paid in every case, right?
Right, and that seems reasonable and fair really to both parties, that the burden on the defendant really is minimal and comports with Nelson. It's certainly not what Colorado's Exoneration Act previously provided. There's no question of proving innocence here.
And can I ask, in the class action, you're not the AG, I understand, but in the class action, is that what they're negotiating right now, an individualized review of each payment?
I would have to defer to the Assistant Attorney General on that
Is he
question,
going to
Your Honor.
argue?
Yes, Your Honor.
Okay.
And in fact, if the court has no further questions with
Okay,
respect. Yes, Your Honor.
I mean, are you, with regard to what burden are you saying for the individualized determination is borne by the defendant?
Your Honor, the Commonwealth is suggesting that the defendant really just needs to establish the basic elements of their claim, that it's a burden of production, which is what the defendant has done here.
But that's my question. What, are you asking them to produce receipts
Well,
of payment back from 2008, 2009?
well, Brown does mention that when the burden shifts under the forfeiture, that there's no violation of due process in the allocation of the burden to the defendant in coming forward with receipts. What the Commonwealth is suggesting here is that what the defendant has put forward, which is an affidavit in support of her motion, would be sufficient, as would be a verified statement.
Why doesn't the docket show this? Like a docket review, wouldn't it show fees paid? Wouldn't there be a checkoff somewhere?
Well, I think the manner in which records are kept varies considerably among the district courts. And again, I apologize to the court, looking at the documents that are part of the record in this case, nothing jumped off the page as to whether or not the fines had been paid, and I think that's why.
So you're saying all they need to do is put in an affidavit? They don't need the records?
Yes, Your Honor.
On behalf of the Commonwealth, that you can represent that would be enough?
That the defendant would simply need to come forward with an affidavit explaining, here's what I paid, here's when I paid, every Monday I came in with a $100 bill, whatever it was. The Commonwealth could either agree with the defendant upon its review of the records or rebut that and say, well, the probation officer remembers, no, you didn't, or here's what the court records actually reflect, or digging deeper, as we did in this case, find a more accurate accounting of what actually
What's the difference
occurred.
between that and the motion form that the CPCS lawyer talked about?
My understanding, Your Honor, is I think that defense counsel is suggesting more of a presumption.
Well, I mean, I don't see a big difference between the form and an affidavit, unless you're going to start nickel and diming the affidavit.
No, and Your Honor, I would suggest that an affidavit would work as would a verified statement.
So a verified form.
A verified form, something that was reliable. And no one is expecting an individual who is homeless and has lost their papers to come forward with pay stubs. If she says in her affidavit or in the verified form that she paid this money, then she's met her burden, and then the burden would then shift to the Commonwealth, either.
What's the difference between your position and the CPCS position? I'm not really getting it.
My understanding, Your Honor, is that the defendant, I think, was advocating that if there was no indication in the record, then there would be a presumption. If there was no indication in the docket or the record, then there would be a presumption that.
The defendant comes forward and said I paid this.
That's right. And I think.
And if the Commonwealth can't come back with anything that shows that's wrong, then the defendant gets paid, right?
Well, I think the defendant's position was, unless there's something in the record that shows that she didn't pay, then there's a presumption, then there'd be a presumption that the defendant did pay. I think what I'm suggesting is sometimes there are additional documents that are not contained in the record, such as in this case, which are ultimately discovered whether through a different record-keeping system that shed more light on whether or not payment occurred.
So tell me how much time you spent ascertaining whether the payments were made in this case, and where the documents came from that allowed you to make that determination.
The determination, Your Honor, with respect to
Whether
whether or
the
not
money was paid.
whether or not the defendant paid.
Yeah.
And actually, Your Honor, I would ask that the probation services be be permitted to respond to that because that's where the information came from.
So it was their time, not yours.
Well, it was the time, my understanding, of a probation officer. There were several different individuals who conducted a review of the records, but I don't want to misstate
All
that
right,
to the
we'll
court.
hear from Ms. Joss as to how much time was spent for this particular case. I gather they had to go back to old probation records and try to go through notations.
I saw a page of a computer printout, which upon receiving this information, I immediately provided to my brother, which clarified that in fact, Ms. Green had paid the full $5,000.
Going back to Justice Lang's question, what if the records are, simply don't make it clear at all whether or not it was paid? Because it was 8, 10 years ago and we just don't know.
Well, there might be there might be another indication in the record, as there was in this case, where Justice Kunis noted that all monies were paid. Even if a specific accounting can't be found, it could be that reading the record as a whole, it's ascertainable that in fact the money was paid or the money wasn't paid, or the case was closed out, as my brother had argued that the AOTC notice indicated the case was closed.
So if it's not clear from the docket, you're supposed to go then back to probation and say, go back and find your files and go through the entire file and figure out how much was paid?
Well, that would be fair both to the defendant and to the Commonwealth, and would result, I mean, obviously the intent of the process is to make sure that the defendant receives money that's owed to her. Similarly, just as when a victim receives restitution, the victim can't receive any more restitution than the damages that they actually suffered. So it would be unfair to have the defendant receive a benefit or a bonus if that money wasn't actually paid. So best efforts obviously need to be made to ascertain what the total amount was.
Best efforts by probation.
Well, I think by the Commonwealth, that would.
We're not the Commonwealth.
Yes, Your Honor.
The probation office is part of the judiciary.
Yes. Well, it would start with when the motion's filed, that the prosecutor begins by looking at the docket. If the docket isn't clear, perhaps further inquiry needs to be made with respect to probation to ascertain, was there another record-keeping system? Is this noted someplace? Were there bench notes, perhaps? Just as when...
Bench notes, I mean, the judge would have to go back and go through his or her bench notes?
I'm just suggesting, Your Honor, that to be fair, it would seem that a reasonable inquiry should be made by the prosecutor to ascertain how much money was paid. And if it's not immediately ascertainable for the record, there could be, just as when the transcript is incomplete and a hearing is held, there was an inaudible sidebar. What happened at that sidebar? We go back before the district court judge and see if the judge has any other recollection of that or what the judge's normal practice was.
And do at times 20,000 cases?
No, I'm not suggesting that, Your Honor, but perhaps I would let the Assistant Attorney General address that
A good
issue.
segue from Mr. Toon to perhaps come in.
Thank you, Your Honor.
Good morning, Chief Justice Gantz, and may it please the court. So as my brother accurately stated, aside from civil forfeiture, there isn't much dispute here as to which exactions are covered by Nelson in these cases. For Nelson to imply, the invalidated conviction must be the sole legal basis for the exaction, and the Commonwealth must have no legal right to retain the funds absent the conviction. So in Mr. Martinez's case, his probation supervision fees are covered by Nelson because they were imposed as a consequence of his probation sentence, and he was sentenced to probation solely because of his 3 felony drug convictions. Similarly, his payment of $1,000 in restitution is covered by Nelson because the power to order restitution derives from the judge's authority to order conditions of probation. Lastly, his $90 victim assessment fee is covered because it was imposed, again, as a consequence of the 3 felony drug convictions. However, we believe that the refund should be limited to $40 because even if Mr. Martinez had never been convicted of the drug offenses, he still would have had to pay a $50 victim witness assessment for his surviving misdemeanor driving offense. The goal of Nelson is to restore the defendant to the status quo ante, the position he would have been in if the invalidated convictions had never taken place, and all exactions imposed on him were either tied to a valid conviction or had been imposed without any conviction at all. I think to cite Justice Gaziano's example, which is excellent, if a probation served a single probation term concurrently for a drug offense and a firearms charge, he wouldn't get a refund of the probation supervision fee where only one of those convictions was overturned. That's not what Nelson requires. Finally, I think there's also agreement among the parties generally as to how refunds should be made in individual cases. The defendant should file, as they've done here, a motion in the court that, the presiding court that handled the conviction, showing that the conviction was overturned or otherwise invalidated and he's not subject to retrial, that the exactions for which the defendant seeks a refund were solely based on that invalidated conviction, and he actually paid those exactions. The prosecutor should then have an opportunity to present supplemental or rebuttal evidence, and the presiding court should make a judgment based on the record before it as to what refund should be paid, and that payment should be made through available sources.
Don't you see this being a very delayed process? I mean, DAs and so forth are very busy people.
Yes.
I mean, how is it, not that defense lawyers aren't, but I'm just saying that, you know, this is just, I can just see this dragging out while the DA or the AG or other governmental officials are just going to keep looking and looking and looking and looking for contrary evidence. I mean, there has to be time limits posted on this.
Certainly, Your Honor. I think there should be the normal time process for responding to a motion in court as well. And to be more general, we don't think it's really fair to impose on any defendant or the court or a prosecutor to engage in case-by-case adjudication of all the Duke and Afra cases that we are obviously dealing with
You
here.
don't?
No, we don't.
So what
We
is
think-
it you want?
We think a global remedy is absolutely necessary, and a lot of stakeholders in Massachusetts have been thinking about and working towards developing a global remedy. We're also in close consultation with the plaintiffs who have brought the federal class action, and we've been having very constructive discussions as to how a fair and efficient system could develop and in what form that any settlement should be entered into.
But you don't have a recommendation now.
No, I think we don't have a recommendation now. But we are working towards that goal.
You
It's a
agree
very, I'm sorry.
with the butt-out principle here.
I wouldn't use those terms, Your Honor. We don't believe that the court needs to devise a global remedy on its own, nor do these cases present the full range of issues the court would have to resolve in order to develop such a global remedy. What we need from the court today are rulings on what it is and what's not covered under Nelson: probation supervision fees, victim witness assessments, fines, restitution, civil forfeiture. And we also need a ruling on when and how exactions should be allocated to surviving convictions. That guidance will be very helpful to all the parties in
You said that very quickly, that last, when and how what?
when and how exactions should be allocated to surviving convictions. This is the Justice Gaziano's firearms charge, surviving firearms charges. So I think that guidance will be very helpful.
You included a restitution in your litany.
Yes, well, restitution was presented by Mr. Martinez. We understand that.
It's moot now, I gather.
It is moot, but I think that, I think the court has enough to sort of say it's covered because
Okay,
it's clear.
it's clearly covered, but the question is not whether it's covered, the question is how to do it when it's a private party.
Well, that's a much more difficult question.
Well, I understand that. Are you asking us to resolve it when it has not been briefed
No,
or
in that
addressed
sense,
here?
no. I take your point.
You're not
Your
asking
Honor.
us to address the issue of restitution, except to say that under Nelson versus Colorado, it's included, which of course
It's
is
a
what
covered
the opinion
exaction in
says.
Massachusetts as well. That's right. I think the issue of sources of payment is a very difficult question. Ultimately, obviously, legislative action will be required to implement a global remedy and may be required in the interim to support individual remedies. And that's something that the parties are going to have to work on.
Don't you suggest in your brief that it should come from the general fund unless it was distributed to specific agencies?
For restitution?
Yes.
Yes, Your Honor. So I think if the money goes to a governmental entity and can be traced to it, as in this case with the Haverhill Police Department, then we think we should recover restitution from that entity. And to its credit, the police department made the refund right away in this case. So, but it's much more difficult, obviously, when it goes to victims of crime. And we don't think in most cases that restitution should be taken away from victims.
Can I ask two technical questions? So the burden of proof, in one of these, the Commonwealth contests that all the fees were paid, and it's a morass. The tie goes to the defendant. What is the burden of proof here? I understand the initial burden of production is being put on the defendant to say he or she paid. Commonwealth has some kind of burden to rebut. What happens when it's just a mess? Because I'm predicting that'll be a high percentage of those.
I think courts are going to have to do the best they can based on the available records, the documents provided by the defendant, any available court notations. You're absolutely right. Some, as one of the amici have pointed out, the court records going back the past 20 years are not always in ideal condition to reflect these matters.
So just is it, if the Commonwealth doesn't, I guess, who wins when it's a mess? Does the AG have a position on that?
Well, I don't think it's helpful to look at this in terms of presumptions or things like that. I think
just trying
a claim gets made to the
We have to come
court.
up with a legal standard of some sort, and I'm just trying to be practical. What's going to happen?
I think it would be the normal preponderance of evidence standard that's applied.
So the
Someone makes a
plaintiff would
claim,
have
I'm owed this money by the government. The court looks at all the available evidence and makes a
So the
determination.
defendant has the burden to prove that they paid the entire amount by the preponderance of the evidence, is your view?
Yes, Your Honor.
Okay. I just
And
wanna
I
make
certainly think that prosecutors and courts should be helpful in giving information from court records and from other documents that would reflect on that issue.
Okay, can I
We
ask
all have an obligation to comply with Nelson, so it's not necessarily adversarial, but there could be documents that could clarify the nature of the claim.
And the second claim is, so I understand the global settlement, I assume you're going to be seeking some kind of legislative payment of that. How is it supposed to work in these individual cases? Is there going to need to be a statute passed to authorize each one of these, or is this, how is that going to work?
What we propose, and at least with respect to things like victim witness assessments and probation supervision fees, what we are hopeful that we will be able to pay those off in the one-off cases by using the incoming funds that are taken from the trial court and deposited with the treasurer into the general fund. That is the general refund process that's contemplated by the victim witness assessment statute. There is a complication because that statute contemplates monthly sweeps into the general fund. It actually occurs on a daily basis. So this might have to be worked out with the general fund, but we're hopeful, at least for those cases, that can be the source of payment. Another possible source of payment could be the settlement judgments fund. There may also be a separate Dukan Farrak fund that the legislature have authorized. There's no clear answer, but I think there are a number of possibilities that we're looking at.
Yeah, could you give I'm sorry.
Please.
I have no idea what kind of money we're really looking at. I mean, has anybody tried to estimate what we're talking about? I know it would be rough, but is there any kind of estimate? Because the legislature's going to want to know this.
Yes, I don't think it's going to be a large amount of money.
Well, I know that,
And many millions of dollars.
That's not really
So I would imagine, and this is just my personal, and please don't hold anyone to this, but I imagine once you combine the Dukan Farrak defendants, it's probably north of $10 million.
North of $10 million.
Yes, that is only my personal estimate based on what I've known from the cases.
Mr. Tunel, I'm not sure I heard the exact same thing as it relates to the burden of proof on whether or not the money was paid. Is it that the defendant has the burden of production, present some information that it was paid, and then the burden of proof shifts to the Commonwealth? Or is it that the burden of proof is on the defendant?
Well, it's complicated into the semantics because, of course, Nelson was very clear that we shouldn't be talking about burdens of proof. I think that anytime someone makes a claim against the government, they have the burden to establish the requirements of that claim, and I've outlined what we view as
That's what I'm going to call the burden of production.
burden of production. Once that claim is made, then the government has an opportunity to present supplemental or rebuttal evidence, and then the court should make a determination as to whether the claim is entitled to be paid, and if so, how much.
Yeah, but it goes to something Justice Kafker said. Tie goes to whom? Tie goes to the runner. Tie goes to whom? The defendant meets the burden of production, and then the Commonwealth is going to contest it. So who has the burden? Assume preponderance of the evidence, like you said.
Right.
Who has the burden?
If the question, I mean, it really is fact-specific. If the question is whether or not the defendant actually made the payment, then I think that's a showing the defendant has to make. So I guess you would say the burden is ultimately on the defendant to establish the claim, and if there is rebuttal evidence presented, but it's really just a matter of adjudicating whether the claim is valid or not. So I'm not really sure about shifting
Well,
burdens.
I think it's going to matter, and I think it could make a big difference. Triers of fact rely on burdens of proof, and the burden of production, which is not going to be hard to satisfy, is going to be on the defendant. But it's not going to be hard to satisfy, as the DA's office said. But who has the burden of proof? I think it really matters. It's the tie goes to the runner question that Justice Kafka was asking about.
Right. If I could just back up, I think when we look at the global remedy, in that case, I think it's actually the burden is on the Commonwealth to come up with presumptive refund amounts. It's not, we don't think that every Dukan defraud defendant has the obligation to go and file a motion like Mr. Martinez has. We think that the Commonwealth has a duty to identify eligible defendants, identify presumptively what we think the money they're owed, and notify them of that and give them a chance to object if they feel that that's the wrong number. So when we look at the big picture, we actually do think the burden is on the Commonwealth, and this is our sort of assessment of how the Matthews v. Eldridge due process analysis plays when you have a large class of eligible defendants.
You're asking the DA's offices to do this.
For the global remedy, no, I think it's going to have to be other parties, not the DA's office. The DA's office, we believe, should be responding to individual motions that are
Okay,
filed.
so when
in
you
court.
said that I don't know who the we is.
Well, it's a lot of stakeholders involved, but I think the trial court and the probation department are definitely.
But the trial court is not the Commonwealth. The trial court's part of the judiciary.
That's the Commonwealth is ultimately the party that is obligated.
But the bottom
under
line is,
Nelson.
I say that because in terms of the detail work of figuring out who paid, you're effectively asking probation officers to go back through their file, find the file, and dig through tens of thousands of file. That's where the rubber hits the road in terms of this burden of proof issue.
Well, ultimately, what may happen, Your Honor, in the litigation or otherwise, is that we may hire a claims administrator to access the trial court probation's databases and make these determinations on its own. So someone's going to have to do the work. I'm not sure it has to be probation officers directly, but someone is going to have to go through all the records, assess, make determinations as to who gets refunds, and administer that process. Unfortunately, the Commonwealth, no one's really the Commonwealth in that sense, but someone has to step up and comply with Nelson.
And that's going to be determined if and when we get to this global remedy.
Yes, Your Honor. And that's something that we're working on, and we are engaged with representatives of the purported plaintiff class who are very well informed on these issues. And hopefully we can make headway with that, particularly after the court rules on the issues in these cases.
And is the trial court or the probation commissioner a party or an intervening party? Part of these negotiations?
The plaintiffs actually just filed an amended complaint in federal court yesterday. The commissioner of probation is listed as one of many defendants, as well as my boss, the head of the state police, the head of EOPS, the governor, the treasurer, all the DAs, and the Commonwealth. So I guess they have a shared responsibility theory as well.
This fund hopefully will incorporate the additional resources that will be necessitated for probation and for the court system to administer this?
I would assume that, yes, Your Honor. The administration of the remedy is going to have to be funded as well as the remedy itself.
And so how long do we wait before we pursue the global remedy which you propose?
Well, I'm not sure if you need to wait at all. The Commonwealth is committed. We know we have to.
I'm sorry, I thought you said we should defer.
Defer, yes.
Okay,
I think
so the question is, how long do we defer?
I think you should defer forever, Your Honor, because we are committed to getting this done. We have to
For
work.
forever?
Well, on as to whether the court needs to speak to the global remedy, that is going to be, we have to carry that out. And it may end up in, someone may challenge the remedy in this court or another court, but this is something that we have to carry out.
Well, I understand that, but the question is, how long do we wait for you to negotiate that and resolve that before we say we've got a crisis in our court system because we may have tens of thousands of these motions burdening our our trial court and our probation office.
I certainly take your point, Your Honor, that we need to act with all possible speed in
Okay,
making
well,
this happen.
we're not going to be speaking about Brown versus Board of Ed of all deliberate speed. How long are you saying we should defer for?
Your Honor, I would say give us 6 months to see what we can do to make this a reality. But it's also going to require legislative action, which may extend the timeline.
Can I ask one other question? The global group is just Dukem and Farrak? Dukem and Farrak defendants, is that that's the global package?
In the proposed class action, they just amended yesterday to add the Farrak defendants, yes.
And can I ask, for these individual ones, I mean, the U.S. Supreme Court case is kind of open-ended. Anytime anybody ever had their conviction reversed, I mean, is there a time limit on this? I'm looking at that ABLE group over there who've tried cases for 40 years. Does every time they won one of these on appeal, is that part of this too? Is that part of the individual group we're dealing with?
I've not thought about that question, Your Honor, and I don't know what our position would be if someone who had their conviction overturned 30 years ago went in to recover their victim witness assessment or something like that. I just don't know the answer to that.
Okay. Okay.
Thank you.
Thank you. Ms. Joss, on behalf of the Probation Commissioner.
Good morning, Your Honor. May it please the court, Sarah Joss on behalf of the Massachusetts Probation Service as part of the Massachusetts Trial Court. As Your Honors have identified, this involves a whole host of thorny issues and significant implementation concerns. As Mr. Toon explained, there have been ongoing conversations that have involved the trial court in terms of looking toward a global remedy, but as Your Honors also point out, that could take some time. So in the interim, I think probation's interest here today is to ask the court to set very clear rules of the road for the individual trial court justices and probation officers, clerks, and other staff who will be confronted with these individual motions in terms of what is it that is the obligation, what makes a clean motion, what are the issues around allocation, so that without taking a position on those issues, just identifying them for the court as these are the things that really require clear guidance, because I think the last thing any of us want is to have a judge sitting in one court and a judge sitting in a different court, confronted with the same sets of questions on a motion for return of property and to reach different conclusions. So I think part of the challenge today is to identify where are those areas that this court can provide clear guidance as to what the trial courts need to look at and need to decide. I think the court has identified several of those being what's a sufficient motion, who has the obligation to come forward in the first instance, and what constitutes a sufficient motion, and again, with the burdens of proof. Similarly, the question around allocation. Nelson makes clear that the only funds that are required to be returned are those that are attributable solely to the invalidated conviction. As Justice Gaziano pointed out, you could have a variety of cases where the person who received Bridgman relief had other charges filed in the same case. And in fact, looking at the data for the group of Bridgman defendants, roughly 21,000, approximately half of them had other charges filed in the same case. So when we think about how does the allocation issue work, we're talking about roughly 10,000 of the people who received Bridgman relief when they file motions for return of property could confront allocation issues.
You raise a good point about not having a different holding in the Lynn District Court than you have in the Waltham District Court. But the other issue is that it's a huge burden on a busy district court and a district court judge and the parties to even have to adjudicate who has the burden of production, whose responsibility is it to go out. Can the fee be put onto another complaint?
It certainly is, Your Honor.
And so when you say that we need to resolve some of these issues, it's not just for consistency, it's for survival.
Absolutely, Your Honor. I think the concerns that this court has identified around how long do we wait, I think is not just a question of do we run into due process issues if we're waiting too long, but I think it's also a question of the longer we wait for a global remedy, the more individual motions the individual courts will confront. Once this court decides these two cases, even if the court limits itself to deciding the claims brought by Ms. Green and Mr. Martinez, that ruling stands for the other 30,000 Dukin and Farrak defendants, any single one of whom could file a motion on any given day. For some courts, that'll be easy. They may only have one defendant. Some courts are going to have thousands, and that really could swamp the operation of the court. So that being said, the trial court stands ready to assist in whatever way it can in resolving this, whether that's in furnishing data, reviewing records. We're certainly happy to do that, but I think having this court set what the rules of the road are makes that implementation a whole lot easier. And I just want to speak to some of the data concern issues in terms of why this is a burdensome thing and why even adjudicating the individual motions could take some time. As I suspect your honors are aware, currently the trial court all shares one case management set of software mass courts. Prior to the implementation of mass courts, and different courts converted to mass courts at different times, there were a whole host of different case management systems. Those legacy systems, not every case converted into mass courts, which means that it's not as easy when confronted with a motion for return of property for a clerk to go in and say, I'm going to pull the mass courts records, which should have records of payments made by this individual defendant. If that defendant's case predated mass courts, then it's a question of having to go back into legacy systems to which the individual clerks don't have access. And in fact, as Attorney Langsam and Attorney Keene pointed out, that's one of the things that occurred here is because Ms. Green's case out of Framingham predated that court's conversion to mass courts, some of the payment data was in mass courts, and working with trial court fiscal, trial court judicial information services, the local probation department, and the local clerk's office, we were able to pull out information from the legacy systems, which is how we were able to establish that Ms. Green had in fact paid the entirety of her fine. That's a process that takes some time. So I think if the court is clear in setting where those burdens lie, what are the clear rules of the road in terms of allocation, in terms of what types of exactions are in and out, it at least gives the courts having to grapple with these motions on presumably at some point a daily basis, the opportunity to perhaps get ahead of the curve. I mean, obviously we have the lists of Dukin defendants, of Farrak defendants, and we have been working diligently. In answer to Justice Lang's earlier question about what's the scope, we've been working diligently to try and come up with what that number is. It's an incredibly complicated process. It's taking months just to get to the point where we can start to make an estimate because we have to collect the data from so many different sources.
Do you have any idea?
I don't disagree with Attorney Toon's representation that I think when we're talking about the entirety of the Dukin and Farrak defendants that it'll be in excess of $10 million, but I don't think I can give a clear number at this point, in large part because it depends on how this court rules on issues of allocation. The class action itself raises other exactions that aren't before this court. So there are a whole host of concerns around addressing even the individual motions.
How about how difficult is it to determine whether someone paid? I mean, it looks like you're going to be able to figure out the amounts that were supposed to be paid. Is it going to be a realistic undertaking to determine whether someone paid all or parts of these things?
I don't know that it's unrealistic. I think the question is how challenging is it? And that depends in part on the age of the case. That, as Your Honor pointed out earlier, this isn't just about Dukin and Farrak defendants. Once this court sets a process for individual motions for return of property, that could conceivably apply, certainly it could apply going forward to somebody who has an assault and battery conviction vacated due to a motion to suppress being granted and the district attorney decides not to re-prosecute and that person spent 2 years on probation. Certainly it could apply to that person as well. Then there's the question, and that's easy because if that happens now, that's in mass courts, that's relatively simple. Mm-hmm. If we're talking about cases that go back and predate mass courts, that's complicated. That isn't as simple as the clerk going in and pulling out the data that records the payment.
I'm sorry, mass courts is, what's the date for mass courts?
It depends on the court. It was not that the entire court migrated to mass courts at a set time. Different courts migrated at different times. So that being said, it's not impossible, but it's complicated.
And it's complicated. It's complicated to get some of the information sometimes, but whatever solution the solution has to have no more than minimal procedures to comply with Nelson. So I guess we need to address what's really complicated with minimum procedures.
Minimal procedures imposed on the defendant.
Right.
Correct.
So we have to reconcile those two
Yeah,
things.
and I think.
Does that tie into the burden of production? Well, no, I put aside the burden of production. Does that tie into the burden of proof issue?
I think it may, Your Honor, but I think it's important to consider the context in which Nelson was saying minimal procedures, that in that context, they were looking at the Exoneration Act in Colorado, which required the former criminal defendant to prove their factual innocence by clear and convincing evidence, much like Chapter 258D does in Massachusetts. So when you're considering what constitutes minimal procedures, I think it's a very different inquiry because you have to compare it to a burden of proving factual innocence by clear and convincing evidence. So I don't think that saying something like the person has to come forward with a motion, has to provide some, whether it's verification or affidavit, and that there's some incumbency on the system at large to review records, I don't think that would violate Nelson's requirement of minimal procedures.
And to give us some order of magnitude with regard to the Green case, how much time by how many people were involved in determining how much Ms. Green had paid?
It's a little bit difficult to segregate that out, Your Honor, because taking the information from the legacy systems has been part of a much longer process to address the global remedy. So to pull out Ms. Green's herself was not several hours perhaps, but that's because all this work had already been done to generate to pull out of the legacy systems the amounts that people on the Dukin and Farrak lists, or at least the Dukin lists at this point, had already paid. So because it's part of the attempt to construct a global remedy, the burden was a little bit easier.
Okay. Thank you.
Thank you, Your Honors.
Actually, Mr. Keene, I've got one more question for you. CPCS is not a party to that class action?
We are not.
When individuals come to the court and seek individual remedy, must they opt out of the class, or are they? Is there any bar for class members to come forward? I assume not.
I assume not also, but honestly, I don't believe the class has been certified yet.
Okay.
Maybe
So this
that-
would be an issue with regard to the certification of the class.
Right, right. But
Okay, and when individuals come to CPCS, are you going to tell them to come to court? Or are you going to tell them to wait for the class remedy, or that may depend upon an individual circumstances? It
We
puts
are going to
CPCS in a
do-
clumsy position.
I can tell you off the record that there have been, outside of the record, I should say,
I'm afraid everything is being recorded, so.
just between you and me. There have been about 150 inquiries to the drug lab litigation unit about, can I get my money back? So we're going to try to respond to each of those within the boundaries of Richmond 2.
Right, okay, thank you. We'll take our morning break.